on the troll.
Hello and welcome to Mzansi. We're back again. It is that time of the day and the night. I don't know which one is it on your side, but yes, look, we are just making sure that we're keeping you up to date with when it comes to the cases that are there and are controversial, and we are giving you a piece of our opinion. And
yes.
Just a disclaimer, this is not a channel that defends people who are accused, but this is a channel that seek to reason with what is presented to them. And we are always going to question if it's not right, if it doesn't feel right. So when we take a certain position, do not expect us when a next case come or next something come to take a certain or a similar position, or a position that is seemingly taking the other position that we took. No, that is not what we do here. Here we just allow you to think, we give you facts, and then we give you our 2 cents. Then you come with your 2 cents.
Yes.
And then from there, we probably are a complete court of public opinion.
Oh, yes. That is the purpose here.
So I see many people get confused and they start comparing. We will break down this case.
Yeah.
Rest assured, we will break it down.
We have to.
We were just giving others a chance because we see that once we start something when it comes to these cases, we get a lot of people doing the very same thing. When we keep quiet, a lot of people keep quiet. So it's our nature then. What we are doing, we will start with the verdict that came today, and then we will take you back.
Yeah.
And we'll give you our position.
And what we think.
We'll
analyze.
Basically.
It's important.
That's what we're going to do for you. And thank you very much for joining us. Please like the video, share the video, and comment. As usual, be civil. We will be civil.
Yes, please.
Thank you very much.
Yeah. So, guys, welcome back to the Mzansi Reality YouTube channel. And we welcome you here with open arms. We are here to deliberate on Bafana Mahungela's case. I've been calling him Mahungela quite a lot, but it seems like the
There's an
pronunciation
H.
is, yes, it's Mahungela.
Okay.
Mahungela, yes.
Yeah.
He was charged with the murder of sentenced school teacher Kirsten Kluyts and was denied bail by the Alexandra Regional Court on Friday. Now he's facing Schedule 6 offense. Okay, Mahungela spent Christmas behind bars pending his bail outcome after a 3-day bail application hearing, which saw him take the stand to give his version of how he stumbled across Kluyts' body on his way back to his residence. He said that he turned her over, and when he realized that she was dead, he removed her clothes, put on her top, a blue top, and walked to a nearby drain where he disposed of her clothes before returning to his accommodation. Now, he said he was afraid that his fingerprints on her clothes would lead police to believe he was responsible for her death. However, the prosecution revealed that CCTV footage captured Mahungela arriving at the park 1 minute after Kluyts, and her phone was found on the path 10 minutes later. The state prosecutor, Advocate Ayanda Bagana, went off to a strong start, reading his heads of argument. They were opposing the bail application of accused 21-year-old student. The state said that the accused denied the fact that the reason why he wore Kluyts' t-shirt was because he was full of blood. The accused said that when he found Kluyts' body was not in a bad condition as shown in the photos. He stated that he repeated the version of the accused. The state repeated the version of the accused and how he explained he was at the party the night before. Now, he said that he took a taxi from Alexandra back to Parkmore, and then he fell asleep in the taxi and got dropped off close to George Lear Park. The state argued that the accused's testimony did not add up and was not backed up by evidence. It is submitted with respect that the only reason the accused will be untruthful is because he was the one who inflicted the injuries that led to the victim's death, said the state prosecutor, Ayanda Bakana. The state, during its heads of argument, said that just because there was no injuries doesn't mean that there was no. The state claimed that this was misleading. Some of the arguments his defense counsel made, his lawyer claimed that he was beaten in police custody to confess to the murder, and the case against him was weak. He said that he was getting beatings. Okay, this is what he told his defense, or the defense counsel, that he was getting beatings and being forced to confess to a crime that he did not commit. No one would ask, if the police had all this evidence and video footage, why would they need to make him make an admission or a confession? Which is why other people kind of seem to be convinced that he did not do the crime. And maybe, just maybe, he was at the wrong place at the wrong time. Mr. Anonymous, what did you think about this?
The argument of the defense.
Yes.
Look, they also have not proven or even given any reason why we should believe that, yes, they might have that harassing that we know that our SAPS are capable of. But if you take it into law, then also they have not submitted sufficient evidence to suggest such. They have just said it out loud.
I remember with the previous video, the initial video we did covering this story, I kind of alluded that maybe I don't believe that happened, and then I caught fire, guys. I heard you. I saw your comments. And even Mr. Anonymous agreed with you guys that I was dead wrong for that.
Yes.
For saying that that might not have happened, because we know, or we have seen with the Senzo Meyiwa case that
to lay the basis of why we believe that could not have been the case is, first of all, this is I would say, a person of no color, a person of you know how they treated that case.
Oh yes, these people.
Yes,
their cases are treated very well, diligently, and
there was pressure basically on it.
Yeah.
There were institutions also that were sort of helping. They gazetted for private investigator.
Yes, there was.
So there was a bit of pressure.
Yes.
I don't think he would have just walked in, and with how he is now, looking at how he answers, I would literally say he's got a bit of arrogance, according to me. So, and he snaps very easily. You could see that when he was asked questions twice, he
becomes impatient.
So that whole process, do you think it would have been smooth process?
No, considering the fact that there's not even a confession that or an admission that he made. No, in my opinion. Hi,
and then again, to submit your theory, to support your theory, also to argue on both sides, you could be right. Or maybe we have seen an extreme, or we have heard of extremes where people will go on to make confessions.
Yes, and admissions.
In this case, you could be right that maybe there was nothing that happened, on the basis that there is no admission statement.
Or a
confession.
If there was,
then you would more. Yeah, maybe we have seen an extreme situation.
We have.
Maybe we are in a current situation where we feel like this is how things should go. But yes, most of the time, these cases in South Africa, you would find that there's confession in most of them. So in this case, there is no confession. And there was no much needed in terms of of actually enforcing the situation. I'm more convinced now on your side to say that you are right. This guy was not hiding the fact that he undressed this woman.
Yes.
So he's already involved.
Yes.
So there's no hassle and tussle of whether you are involved or not.
Or not, yes.
Yes. So in this case, you probably are right.
Well, I wouldn't know, it's just me and my opinion. I wouldn't say it's a fact, guys. It's just speculations here, okay? We are working with speculations. And I wouldn't say that 100% correct. It's just how we roll here on Mzansi Reality. We look at all angles. Akira, Mr. Anonymous.
And to also submit further, it seems as if money is not a problem from where it comes from.
Right.
Because look at the issue that they want to appeal this, right?
Yes, they want to appeal.
That tells you that they are not. There's an advocate there, by the way.
Yes,
There's an
that's
an
that
advocate.
man, that
arrogant lawyer
is an advocate.
So that they don't come cheap.
No.
Criminal.
And he's with an
advocates.
attorney. Did you see that?
Obvious is appointed by an attorney. So they approach an attorney, and this is not just any attorney.
Did you see the attorney?
Yes.
So it seems like money is not.
It's
that
not.
much
It's not.
of
They probably are not that rich, but they are also not. So
not poor.
immediately when he was captured, I'm
He
sure the
called
parents
lawyer.
they were involved.
Yes, because the lawyer did even say that he was contacted on the 29th, the advocate, on the 29th of October. That is the same day he got arrested.
So you see, I'm more now inclined to believe your theory in this case.
Well, the state's case at the point in time is found wanting, and it is groundless. It is clutching at straws. This is the state as they were making their heads of argument before the bail was made, or the bail was announced. At best, it is flogging a dead horse, hoping it will wake up and start to run. Then the defense began their closing arguments. Advocate Itumeleng Masaku for accused Bafana Mahungela, opening, he said, my Leonard colleague's
The
case.
state or the defense?
The defense.
Yes.
He said, my Leonard colleague's case is weak. It's been a trial by ambush. Do you think, first of all, this is not a trial yet? Do you think he's valid in saying that it's been a trial by ambush? But for me, I look at a bail application differently versus the trial. Do you understand what I'm trying to say? For me, a bail application is very different from a trial. So yes, we understand that he wanted to see the recordings and all of that. He wanted to see them, everything. But for the state to release every piece of evidence they have during a bail application, I don't know where they do that.
No, they couldn't do that. They need to keep him guessing.
Exactly.
And in fact, the decision to turn against sending those videos was a good decision, considering
so?
Yes, considering the prosecutor that I saw.
Hey,
I'm not happy about the guy.
it's not make sure.
Yeah, I'm not happy about the guy. In fact, without being arrogant, you could tell that the advocate has been a prosecutor before.
Yes, he did say he was a prosecutor.
Yes, and those are normally, they make good lawyers.
Defense
Yeah,
attorney.
good defense attorneys. Yes, like Mnisi.
Mgomezulu, I think he
Mgomezulu has never.
Oh, he's never.
Mgomezulu is just
Mshololo.
it's just a special breed. Yes.
Mshololo has worked as a state prosecutor.
Knowing
before.
both sides. So I feel also that this a state lawyer is not gonna go to the main trial. That's my feeling, this was done, I think, as when we were chatting, probably to balance the forces, to make it look more favorable for a person of no color, of color. Yes.
Because already a lot of people are making this a race issue.
Yes.
It's because she's a lady of no color.
It was to diffuse that, because if the state prosecutor was of no color, and the judge is also of no color, then it was going to be an issue.
It was going to be a problem. But I have to also express my underwhelming feeling that I got when I looked at that prosecutor. I mean, his arguments were very short and they didn't have meat. They didn't have why this person is not supposed to be released on bail. He just narrated everything that he had said. Not much meat. And honestly, I felt like that defense advocate mopped the floor with him.
Yes,
in
but
his arguments.
You know what killed this case to reach this verdict, that eventually
the guilty.
Not guilty.
My apologies. The denying of bail.
The questions that were asked by the judge they had meat. We will discuss them. I don't want to discuss them now. In this video. We obviously are still going to discuss it further, but those questions were relevant. Even the advocate himself stood up and said, "Thank you for asking precisely and relevant questions." The advocate said that, the defense advocate.
Yeah, well, we are going to get into that at a later stage. So you guys also comment if you want us to continue, okay? Because if you don't say anything, we move, okay? The defense advocate Tumelo Masako state charges are malicious and prejudiced. Their investigations are incomplete. That's what he said. And he further argued that if the accused knew her and was following her, where's the evidence of all of this following? The accused legal team wanted the video footage to show that he was indeed following the deceased, and he has been charged with premeditated murder. So the magistrate citer Prinsloo said the accused and his representatives failed to prove that he should be granted bail. She believed that the state proved that there was prima facie evidence of premeditated murder and robbery, while Mahungela pleaded innocent as he did not flee after the incident. Prinsloo said that probably remained in Gauteng as he believed evidence leading to him was destroyed. Now, the magistrate is alluding to the fact that the reason why Bafana was so cool, calm and collected and stayed in Gauteng instead of running away is because perhaps he believed that the evidence that was leading him or that was going to get him into trouble was destroyed. Now, when she says evidence, she's talking about the clothing.
Yes, and you obviously have to look at what Bafana said.
Okay.
In his own words, he said that why would he run if he was charged with a less scheduled case, not Schedule 6, like stealing, for example. Do you understand? That's what he submitted. If it was a case less severe or doesn't have that much pressure, there's no need for me to run. That's what he said. So now that we are charged, there you can give the state. They argued. I mean, they played him there, because by him saying that is literally saying that should he be given bail on this case, as now it's not just you stole sugar or something.
Yes.
Then that would warrant him to actually try to escape or go somewhere. Do you understand? That's what he was alluding to.
Foot in mouth disease. I knew that somehow that whole talking that he was doing was going to catch up with him somehow, somewhere, somehow. Yes, he's intelligent according to a lot of people and what they were saying. But Hi, man. Too much information, too much defense, too much, but we'll get into it at a later stage. The defense advocate Itumeleng Masako argued that the charges against Mahungela are malicious and prejudiced, pointing out incomplete investigations. Oh yes, this is always an issue. I also wonder about it, Mr. Anonymous, is why is it that the state and the police, they never conclude investigations? I can understand that, but why is it that every time it's almost like this situation, or with most of the cases that I've seen? I understand that investigations can be ongoing, but they have CCTV camera. They have a lot. Why is it still incomplete investigations? I can understand with the part of DNA testing. I can understand with the lab work. I can understand with all of those parts. But I feel like there's not much tangible evidence.
No, I would say that in this case, the state was not prepared for me. So they just scrambled, and eventually, luckily for them, it went well in court today. But they were hiding a lot. And you cannot blame them in this situation. Hearing from the advocate, who was seemingly also trying to get something out of this, it was like a mockery. This bail hearing was more like a mockery trial.
It was the battle of the egos between the state prosecutor and the defense lawyer, or the defense advocate.
I'm wrong if I say mockery. Yes, there was mocking there. It was a mock.
They were throwing shade. It was a mess, in my opinion.
So, in a sense, what I'm trying to say is that it looks like they were just doing a pre-trial.
Oh, that's what you mean. Oh.
So, well, it flies because also the advocate was mocking there. So it was just a mocking situation that was happening there. The arrogance which lawyers have, obviously, we talked about it. It seems as if for me, he was looking for what you have in your hand. Show me the full hand.
Oh, show me your hand.
Show me what you have. Show
so
me
that
both
I can
hands.
have enough to defend my client in the trial.
The bail turned out to be just a pre-trial, in a sense, in his argument and how long it took, hammering on the issues that they must bring all the evidence they don't have, calling them a bluff, so that they show what they have in their hand. So the state did well by hiding what they have. If it's worse, we will hear on the main trial. If it's not worse, then we'll say for them.
We'll come back and swallow our words, right? We always do.
But I don't think the prosecutor that was there today is the one who's gonna deal with the main trial. No,
I know that one.
I don't think.
Make sure. Ayanda Bakana, state prosecutor. He scares me. He
looked all over, and maybe it helped also this bail. These submissions they are making about the towers, we have dealt with this in Senzo's case.
Yes,
I mean, as a law person,
as
a person who also, must always read about or be updated about what is happening around this.
Court.
Yes, you should have known that the towers, from what we heard from Senzo, they actually they connect to whatever
the
nearest what is powerful at the time. If the tower in Sentin was powerful, then they're gonna connect in Sentin and then move away from Sentin as you connect to Renbeck.
Exactly, and you might be in Sentin.
And you might be in Sentin. So Renbeck. A tower cannot be you cannot use the tower mapping and say that based on this
your
you were there.
Your location is there.
Maybe you can, in a sense of province, or in a sense of
a
town.
wider
Yes.
range of
But
area.
you do not nail it exactly where the person was. That's what we
was
are not
interesting.
lawyers, but we
Yes, the
now know
defense
that.
brought that issue up in their arguments that you cannot do that. You cannot. And another thing was the bringing of an expert. Why is the state the one placing his client there instead of having an expert to come and explain to the court what was happening? And I felt like, okay, maybe these are the issues for the trial, the main trial.
Yeah, the guy is canvassing what he was even telling them what he's going to say and how he's going to argue in the trial.
So he helped them. He's helping them prepare.
His arrogance is doing that.
So, yeah, Sita Prinsloo, however, said that the bail application, that's the presiding magistrate, was not convinced by these claims. The magistrate stated that given prima facie case against the applicant, the court is of the opinion that the applicant possesses danger or poses a danger to society, especially to the women in our community. Now, a lot of people have issues with the statement of magistrates saying that Bafana poses danger to society, especially women in our community. What do you think about this statement? Is it too harsh?
No, it's not too harsh. It's not even far-fetched. I think it's a correct way of arriving to your conclusion of what you are going to give as a final answer. So, I mean, this person we're talking about, Bafana, he undressed a deceased person.
Abana, that part.
Fully undressed that person. Fully undressed that person.
Left them naked.
That also got me because I was thinking maybe they had undies, and all that. But when I heard that, when the judge was probing that, and I heard that this person was like, eventually, he was like naked. And this is a woman. And already there's something dingling in your face that you could have been the one who was involved there. Would you take chances and say, on the basis, now the situation here, does women as a whole rights outweigh an individual right? In this case, yes.
Because the victim is a woman and
Yes.
she cannot speak for herself. She's deceased.
You are protecting the society at large. As much as this person is not proven guilty as yet,
Yes.
but do you want to take that chance?
The risk. It's a question also of that.
Do you want to
if
take that chance and say, okay,
the bravery and boldness to address a corpse, then what more a vulnerable somebody, who's female? Perhaps maybe they are unconscious, or maybe they have they've partaken in diluted waters,
yes.
or something that they are in a vulnerable state.
I think
Would they help?
considering the fact that there is no rush to be outside, on the basis that the school also has suspended the activities that he was doing there with them, he's better off there at this point in time
Than outside.
Because what if you take a chance and then this person does, or something like this happen at more cases of such things, 10 people now, would you be able to live with yourself?
I think I wouldn't. And I wouldn't want to take that risk.
Exactly. So the best decision was that let us keep you here while we proceed with everything. In this case, it's not like you stole or it's alleged that you stole Norox or something like that, something that can be replaced.
Now, the magistrate also said that they failed to prove exceptional circumstances for his release due to the seriousness of the charges against him.
Yes, what is it that you want to go outside and do, really? That is important.
She further pointed out that Mahungela had disposed of Kluyts' clothing, potentially destroying valuable evidence,
Yes.
and had failed to report the discovery of her body to the police.
Yes.
The court is of the opinion that the applicant took deliberate measures to avoid sanctions, eliminating any evidence that could incriminate him.
He himself submitted that. He's the one who said that I was
Yes.
trying to be not involved with the police. So, if there's any evidence that is outside, then that evidence is a danger. If the investigation is still in progress, then that evidence is in danger. You are capable of disposing evidence and hiding it and not handing yourself in. How much more if there's someone who saw you,
Who's willing to testify?
who's willing
be
to
a
testify?
witness.
How much? And
Because
we're talking.
even the defense was hammering on where are the witnesses? Where are the people that saw? Why should they be brought now in a bail application? Why should they be brought in a bail application? They can be brought in the main trial.
You are not ill with terminal disease. There is nothing basically you are fine. So the best option in this case is to protect society on the basis of what you are accused of, and also on the basis that you are capable of disposing evidence. You are capable of destroying evidence, and after destroying it, you did not report yourself. It had to be investigated, and then you were caught. So in that case, yes.
You went and gone and be arrested.
So in that
Never
case,
handed yourself in.
in that case, then there's more points against you than for you.
Well, she further said that consequently the court believes that the applicant did not flee the province because he believed that all the evidence against him had been destroyed. Therefore, the applicant's application for bail is denied. Prince Lou further noted that Mahungela failed to provide any circumstantial evidence to support his case. As a result, the bail application was also denied. So circumstantial evidence, from what I read, is evidence of facts from which conclusions can be drawn in a criminal trial. So that's what circumstantial evidence means.
Where did you get that?
On Google.
Okay.
I got it on Google.
All right. Continue.
So it is now understood that Mahungela intends to apply for leave to appeal, and Prince Lou's judgment on an urgent basis, signaling that the legal battle surrounding the case is far from over. Okay, guys?
Yes.
On the 19th of January, they are planning to appeal. So the state in the case says that bruised and naked body of the victim led them to believe that she was violated, and they say that they will await the district surgeon's report to make their case. So last week, the state prosecutor, Advocate Ayanda Bakana, argued that there are other factors to determine if one had been or someone had forced themselves on the deceased. The only person who can comment on whether the victim that happened to them, they were offended in that manner, is a district surgeon. One is not supposed to be excited that there are no obvious injuries, and the question of injuries is not only the only element. That's what he argued last week. So there was last week a bombshell that was dropped that there was no damage or visible or seen damage on the area, the private area of the deceased, in all angles, front to back. And that led many people to conclude that the offense of forcing himself on on Kirsten did not occur. But the state says we shouldn't jump the gun. We shouldn't be quick to admit or to say that, come to the conclusion that the offense did not occur, right? Because a district surgeon still needed to do further tests, and they're waiting on the outcome of those further tests. Now, those tests will also include DNA.
What did you say about, what did you say about circumstantial evidence?
I forgot what I said.
Circumstantial evidence refers to evidence that does not directly prove effect, but allows. That's what I know about circumstance. That's why I was asking you.
Oh, that's why you were shocked at my definition.
Yes.
So,
It circumstantial evidence refers to the evidence that does not directly prove. It does not directly. It's not like it. It does not directly prove effect, but allows inferences. You can draw inferences from it.
Oh, okay.
To be established. So, unlike direct evidence, so it's like how would I put it? The issue of the towers.
Yes.
It's circumstantial.
Oh, it's circumstantial evidence. That's an example.
Yes.
Okay.
Because now we want to prove that this person was there. But you do not really have evidence to say that you were there. But you are saying on the basis that there was connection around these towers, I'm saying that you are there. We obviously dealt with this issue. You cannot use that, but I'm just that was circumstantial evidence.
This definition is wrong to say that it is the evidence of facts from which conclusions can be drawn. It's wrong.
Well, here they are saying evidence refers to evidence that does not directly prove effect.
Okay. That makes sense. Like the towers, it's a perfect example. I got that one. Okay. My apologies.
Not a problem.
So, yes. Yeah, so one is not supposed to be excited that there are no obvious injuries with regards to the whole situation of Kirsten's private areas not having found damages on them. So, yeah, a lot of people have already concluded that the assault did not take place. And the state is cautioning against that to say that they needed a district surgeon to look.
Look, I'm of a view that it did not happen.
Okay.
I perhaps hold a different view in terms of what could have happened in that day, in my own thinking and my own assumption. I do believe that it did not happen. In my own thinking, whatever that was meant to happen was disturbed by the circumstances that followed after that. That's my own thinking. But we will deliberate on that as we follow those
court proceedings.
We're still going to come back with the video that deliberate with the first one and the second one. Then you'll understand where I come from.
Okay. So, guys, hold on. So, when it comes to the failure of his lawyer proving that bail should be granted, I agree with the magistrate on this one. I did not hear much of bail conditions being checked. Like, okay, I did hear about the address, that his address could be verified, which is good. But then other things like he won't pose a danger to society. People are safe. Having character witnesses come and testify that, you know what, he's a good boy. He behaves. I did not see the defense really tackling these issues in order for his client to get bail. And that's in my own opinion. I'm not a legal expert or anything. thing. But we've seen this type of
He
tactic
mostly
before.
focused on nullifying the arguments that were
Yes.
not even the arguments, for that matter, for me, when it comes to state submissions.
It's almost
all
like he
those
wanted him
arguments.
to get a get out of jail free card and in fact drop this whole case. That was his approach.
He was more dealing with the arguments that were raised by the states, and which we have dealt with. We do not have faith in them. They are not solid. If anything, the questions that were raised by the judge to Bafana, those are the questions for me that sort of put a nail in that coffin.
And other, points like he will not, for example, attempt to contact any of the witnesses. That lawyer of his.
He focused on saying that there are no witnesses. We're told. Do you understand? You're arguing the main trial in a bail hearing proceeding. That's what happened.
Client out on bail. Bail is not supposed to be that much of a complication, but he made it complicated. So all I heard was a lawyer arguing with ego and throwing shade and at the state prosecutor, all of that drama, and I must
I don't know whether they have personal vendetta against each other.
It feels like they have history
They
or something.
probably faced each other, but all I'm going to say is that the guy is good. But the problem is also that with your ego, as much as you are going to show your arrogance and whatnot, it might play against you sometimes. But I'm not saying in this case that was the case. In this case, he did not submit enough information to prove the need for this guy to be out, and also to prove that there will be no interference with the investigation and the case itself. So that's why this guy did not get the bail. There was no headache in thinking. You understand? Like, my client is writing exams, for example. My client needs to prepare for exams. There was no such.
No. Actually, he's fine.
So there's no much harm other than not seeing your family, and which obviously you were not in any case because you are not staying with them. There is no harm in you being kept there.
His guilt or innocence will be proven in the trial.
Yes.
Right now, his task was to get his client bail, and he did not focus on
He's
that.
a good lawyer.
He is.
Well spoken.
Perfect. For the trial, he's the kind of guy you need,
Yes.
But the bail process, I found it to be strange in how he was tackling it, in my opinion. And I think we've seen this before with the Nandipa case, Mururi. Do you remember those guys?
Yes. They were doing the very same thing. It seems as if
the state to show.
The issue of bail, what I'm gathering from these lawyers that we see there.
Yeah.
The issue of bail has no speciality in it. They don't put emphasis on it to understand more on what bail should be all about and how to actually crack bail. Most of these lawyers, good or bad, they always suffer when it comes to bail.
I'm seeing that, and I'm shocked.
Instead of going there to fight for you to go out on bail, they end up sussing information that they are going to use in the main trial. So the question is it always good to hire the same lawyer that will represent you on the main trial to
For
actually
the
bail?
bail.
Or should you get a different lawyer to focus on bail?
That's a good point to learn about. And even him throwing shade, saying that his learned friend cannot read or did not read or something like that. I'm like, is this all of this necessary? Because it's not looking very professional. It's looking very much disrespectful.
No, the gloves are always off when lawyers meet. there's
And he
always
was
that.
carrying some bail textbook talking about the application bail process. And he was saying that his learner colleague doesn't read. And I'm like, did you read this? Because from what I'm seeing, you need to represent your client so that they get out on bail. And it doesn't feel that way. It feels like the main trial.
He did a research, but for a wrong exam.
Okay, that makes sense. So interesting details are that there's allegedly also 6 video footages that have been collected by the investigating officer that placed Bafana at the crime scene, allegedly. Now, as we all know, the defense wanted the state to release that footage so they can see magistrate, they can see them. But the magistrate argued that this is a bail hearing and not a trial. So the state is not obliged to release all the evidence they have in the bail application.
As far as we've discussed this, that's exactly what eventually leads to.
Okay, so yeah, guys, the body of the Delta Park High School teacher was found near the path, a certain sports club, after she vanished while taking part in a My Run event in Parkmore. And a month later, Mahungela was arrested after video footage showed him in the vicinity and captured him wearing her t-shirt. But Mahungela, a varsity college student, said that he found the body and turned her from her side onto her back to check if she was still alive. After realizing that she was not breathing, he took off her clothes to avoid leaving his fingerprints. He said he could not elaborate on why he wore the t-shirt, but conceded he later threw away her clothes. He said he left her cell phone next to her body as he did not find it necessary to take it. Now, these are the nitty-gritties that bother a lot of people. Now, a lot of people are asking, Bafana had his cell phone. Why didn't he call at least, you understand, for the police or for help or for anything? You know, these are the nitty-gritties that people are concerned about. And the accused says that he was searching for a pulse and heartbeat when he found Kluyts' body. He says that he panicked and that's why he took her clothes off. He was worried his fingerprints would be found. And he was seen leaving the scene wearing her t-shirt. Now, he told the court that Kirsten Kluyts was not wearing any underwear or a bra when he undressed her. He said that it was easy to undress her and told the court that she was definitely dead. The accused does admit that he did discard Kluyts' clothes. He was seen throwing away her clothes in a water drain system. Now, his case will be postponed to the 19th of January. Well, guys, that's a wrap for now. We'll be back with another session, but that's a wrap for now. Thank you so much for joining us and for watching. And until the next one, don't forget to comment, like, share, and subscribe. Until the next one, bye from us.
Bye.